Elliot, you may proceed with the program.
Great. Well, thanks so much for joining. My name's Elliot Golding, and thanks for joining the webinar today, which is going to be about evolving AdTech requirements in the health space. This is presented by the ABA Science and Technology Law Sections E-Privacy Committee. I co-chair that committee along with a few others within the ABA. And if you're not a member, you should join. We have lots of great programs and put out good materials and meetings. Feel free to reach out to me directly if you're interested. So we're going to mute all microphones today, and webcams are going to be turned off. So no technical issues, but if you have any questions, we encourage you just to put them in the chat and we'll address them as we go through the presentation, or our contact info should be on the next page, and feel free to reach out to at least the folks at McDermott here. As a reminder, this webinar is being recorded. So with those formalities out of the way, again, I'm Elliot Golding. I'm a partner in DC at McDermott. I've been doing privacy for about 15 years and specializing in health privacy, and I'm just very thrilled to have such a great panel of other folks here with us today to talk about these issues. If you guys can introduce yourselves, starting with Erica.
Good afternoon, everyone. My name is Erica Matos. I'm an Associate General Counsel at Elevance Health. I've been practicing in the privacy space for about 10 to 11 years, and just intrigued and excited to be in this space and time in the privacy world as it continues to evolve, and looking forward to some good discussions today.
Great, thanks for coming. Thanks for being here. Amy?
Sure, it's nice to meet everybody. I am a partner in our Boston office at McDermott. I also do a lot of work in the health space, helping traditional healthcare companies come digitize their offerings, as well as working with companies that are not traditionally in the healthcare space and helping them understand health privacy law. So very excited. AdTech is one of the things I focus on, and really looking forward to having this presentation today. And Saba, over to you.
Thanks, Amy. Hi, everyone. I'm Saba. I'm a third-year associate here at McDermott. I work pretty closely with Elliot and Amy, typically more on the general privacy side, focusing on AdTech requirements and digital advertising requirements under more comprehensive laws in the United States and in other countries. But as it always comes up, we have some cool kind of health tech clients that I find myself working with frequently. So a lot of my work also focuses on advising health clients on what their obligations might be under general privacy laws.
Let's go to the next slide. So here's what we're going to cover today. Starting off with just sort of a regulatory and litigation landscape of the use of online tracking technologies, particularly in the healthcare space, some of the enforcement and changes that we've been seeing. And then for folks who are less familiar with the digital advertising ecosystem, do a little bit of a overview to get folks up to speed on that and tracking technologies more generally. And then we'll go through some of the details of what information is collected with those, when's a PHI, going through largely the OCR bulletin on this issue from back in December. And then finishing up with some discussion of, well, what if you're not subject to HIPAA and you're doing this? What do you have to do with? And that's going to be a mix of state laws and other things. And we'll end with some practical tips and suggestions for what companies should be thinking about and doing in this space. So just a quick disclaimer: it's educational. It wouldn't be a lawyer presentation without a legalese disclaimer, but basically it's educational, not providing legal advice. And with that, why don't we get to the substance? So I'll start here. In December, OCR issued a bulletin about the use of online tracking technologies. And at its heart, it didn't really break any new ground, right? It sort of reaffirmed what folks who've been doing this for a while had been advising, and what we had been advising clients, which is, if you're using these online tracking technologies, which can collect information about people and their devices, and it, could very well meet the definition of PHI and lead to an unauthorized disclosure or something like that, and to be very careful, particularly online, on websites and in mobile apps. And so that bulletin came out, and maybe it was because all the attention that's been paid to these issues under all these new state laws like the CCPA in California and the other 4 or 5 laws. We've been seeing federal laws about this being proposed. The timing, I don't know exactly why, but they did that, and shortly after, and well, actually starting before then, OCR has been doing compliance reviews, sending out questionnaires like they would in response to a breach, only it's not being triggered by a breach. They're just sending these out just to, out of the goodness of their heart, to ask questions, which I'm sure everyone would welcome, but asking really detailed questions about how companies are using these technologies and whether they may have impermissibly disclosed PHI. In addition to that, there's some litigation and other regulatory enforcement that's been going on. And if Amy, you want to pick it up from there.
Sure. So some of you might remember about a year ago, there were a couple headlines, over the past several months over cookies. There were articles published by the Markup and Stat that examined tracking technology practices among a number of organizations in the healthcare industry. And so, the FTC, state attorneys generals are also getting wind, so are plaintiffs, attorneys. And I think some of the bigger news is in the last, I think in March, so just about a month ago, the FTC announced an enforcement action against BetterHelp, which is an online counseling service. They alleged that this company shared consumers' health information for advertising purposes in violation of Section 5 of the Federal Trade Commission Act. And this followed another enforcement action announced by the Federal Trade Commission against another online healthcare company. And this is really the FTC, the Federal Trade Commission, entering this new space in force. They are enforcing privacy practices, long tried to enforce privacy practices, but really narrowing in on the use of sensitive information, in this case, health information, and leveraging, pretty wild, pretty hefty fines. And so, again, while these plaintiffs lawyers, OCR, the FTC and state attorneys generals are all zeroing in on the use of cookies, and in particular, the collection of sensitive information. We are all just, waiting to see what the next big wave of litigation is going to be. But all of this is to say is that tracking technologies are in the spotlight, and we're all happy you're here so we can talk about it a little bit more together. So with that, Saba, I think I'm going to turn it over to you to talk a little bit, just to level set on what are online trackers and what's the technology we're talking about.
Yeah, great. Thanks, Amy. Yeah, I think before we jump into kind of some of the requirements and things you should be thinking about, it would be helpful to kind of set out the landscape of the types of activities that we're talking about that are kind of the focus of this increased activity by regulators. So the big focus here is really using cookies and tracking technologies for different types of advertising. And as you'll see on this slide, advertising is a pretty broad umbrella to describe lots of different ways that you can use data derived from several different tracking technologies, which we'll talk about in the next slide, to kind of customize and target advertising based on that data you've collected. So a really common form of this is retargeting, which is basically taking information from your activity on one website to provide you with ads on another. So this is something you are probably very familiar with if you have been online shopping for a jacket, and the next thing you know, you open up Instagram or you get on another website, and all of a sudden you're getting a bunch of ads for different types of jackets. That's a classic case of retargeting. There's also interest-based advertising and audience-matched advertising, which is a really two popular forms of advertising. So again, this is kind of more an aggregate, taking information that cookies and tracking technologies have been able to gather about you over time and across different websites, to put that together and create kind of a profile about you and tailor ads to you based on your interests. So to use myself as an example, let's say that my searches on one website indicate that I'm a woman. My searches on another website indicate that I am in the age group 18 to 35. And then also my IP address indicates that I am in the Los Angeles, Southern California area. So all of this information collected across different websites can create this profile about me. And maybe advertisers will say, hey, well, this woman who's 29 in Los Angeles is probably interested in green juice. So I will see a lot of green juice or like kombucha ads when I search around based on all of that information that's been collected across different websites, because it's connected to the inferences that they've been able to gather from the data collected through those cookies and tracking technologies. And then the last two ones I want to talk about are contextual ads, which are basically ads that are served based on the content of the page you're visiting. So if I'm searching for jewelry on Google, I might see some ads for specific jewelry brands. And then there's also location-based advertising. So if I am using a mobile app that is tracking my, where I've opted into sharing my location, or maybe as the example I provided earlier, any location that's been able to be derived from my IP address, which is one element of data that cookies and tracking technologies can collect. Ads can be served on that location basis as well. So maybe concerts that might be of interest to me in my area. So those are just a few examples of kind of the broad swath of advertising that can take place based on the huge trove of data that can really be collected from cookies and tracking technologies, not just on one website, but across different websites, which is why this information becomes kind of so tailored, because you're able to gather activity across websites over time. And then beyond advertising, as I'm sure you're familiar, cookies aren't just used for those purposes. There's also a lot of kind of website specific purposes. So a lot of websites will use cookies to perform analytics of their websites to see how people are using their websites, the pages that are most interacted with, and how to optimize, kind of make your website more appealing to visitors. There's also just kind of performance in general, like necessary cookies to remember people's preferences and kind of customize the content of your website based on what they've visited before. So you might find, so a lot of websites not only use cookies and tracking technologies for advertising, they'll also use them just for website customization purposes. So with that, I think it would be helpful to talk a little bit about the different types of tracking technologies that can be used to gather all this information and to achieve those advertising goals, to achieve those analytics goals. So the most common one everyone's probably familiar with are cookies. And so we can typically think about this as a first-party cookie versus a third-party cookie. So first-party cookies just remain on the website that you're on. It's on your particular website. It's not shared with third parties. And first-party cookies are usually mainly used for those types of analytics and customization and performance purposes that we just talked about, whereas third-party cookies are placed on a website by third-party users. So typically that data that's collected by a third-party user is shared with third parties. Those third parties then might share it with other parties. And those are the kind of cookies that are really used to collect data across different websites and shared across different websites to create those kind of user profiles to tailor advertising.
Just to jump in here, people will often use the term cookies to mean globally, like all tracking technologies. Like if in GDPR, they have like, a cookie policy, but cookie is just sort of a shorthand to mean like all of these. So we just want to take a minute and explain. We're actually talking about a much broader range of things. And with cookies in particular, like first party cookie might be an authentication or security cookie, right? Dropped by that website owner to help with that particular website, as opposed to the third party, like, Google Analytics or whatever that's being used by a third party to do something with the data. Sorry, jump in there. Just wanted to clarify.
No, yeah, for sure. And that's just the reason we want to go over all these different types of tracking technologies and not just focus on cookies is for that exact reason. All these enforcement actions are looking at all of this kind of activity on your website. So it's important when you're kind of looking at your website and trying to figure out how to align with these new requirements, you're not just looking at cookies, but you're also looking at web beacons or pixels, which are kind of tools that you can use to check if users have access to certain content. They also track like pages visited and general information about how websites are used and searches that are run. There's also session replay scripts that get even more granular and kind of record a user's activities. So you can actually see when someone has typed something in, when they backspaced it, different places they clicked, how their mouse actually moved across the page. So that gives you a very granular look of how people are actually using a website beyond what cookies and web beacons might be able to tell you. And then there's also fingerprinting that's used. So this allows a website or a third party to take all of the information that's collected from these types of tracking technologies and really connect it back to particular users using different types of IDs. So fingerprinting uses device information that's available when you access a specific website, like the device name, the IP address, the operating system version, using all of those types of identifiers to track activity back to a certain device. So that way those ads can be tailored when that device visits another website or web domain. And I'll pass it off to Elliot now to kind of talk about how this works in the workflow.
Great. So if folks have questions, by the way, feel free to add them in the chat as we go. Just the digital ad ecosystem is really complicated and messy, but at its base, it works that someone wants to place an advertisement to someone online, right? And there's a publisher like a social media site or a news outlet that has space for rent essentially on their site, which is where you might see a targeted ad. And it seems simple enough, but the way it actually works behind the scenes is one of the most complicated technologies ever, including a thing called real-time bidding, right? So the advertiser says, here are the kinds of people I want to market to or target. Ads, it might be, women over 50 who live in a certain area or have certain interests or preferences or whatever. And generally that goes into what's called a DSP or demand side provider. At the same time, the publishers have space for rent, but there's so many potential bidders, they make their space available usually through an SSP, a supply side provider. And those all then come together in this middle of this called an ad exchange, where in real time, and I'm talking like milliseconds, right? Upon a page load, it'll say, okay, here are the characteristics of whatever device is accessing the site, who wants it essentially, and whoever wins the bid, usually it's priced at something like clicks per mil, which is, clicks per thousand, 250 is pretty high. It might be like 6 cents clicks per thousand. That's who sees the ad, right? The reality is that there are probably hundreds, if not thousands of other intermediaries in this process, but at its core, this is what online advertising generally looks like. So why don't we keep moving then? Saba, back to you.
Thanks, Elliot. So the last thing we want to briefly touch on before we kind of jump into some of the more substantive requirements is just a brief overview of the types of information that you can collect. And Elliot and I both touched on the fact that it's a pretty wide trove of data. So the first thing is that typically an ID will be created or used to associate all the information that's collected with a particular person or device. So this can be the mobile device ID, which is actually associated with a particular smartphone, and iPhone users can find out what their mobile device ID actually is. Or it might be an advertising ID, which is just a string of numbers that an advertiser assigns, allowing that advertiser to track a particular user's activity. So all of the information that's collected will be tied back to an ID that's assigned to a user or a device. And then using all these cookies, web beacons, all of these different types of tracking technologies used across different websites. There's a really wide kind of array of data that can be collected. So there's a few examples on this slide: the date you accessed a website, your IP address, and derived from that your geolocation, any information that you entered into a web form using a session replay tool. But it really goes beyond that too. So it can also include like pages you visited, how long you were on those pages, all of the websites you viewed, all of the things that you searched, your browsing history and your search history more generally. And being able to collect this across different websites and having different third parties being able to all aggregate this information into kind of a profile gives advertisers and different websites a lot of really tailored information to kind of target those ads in a very specific way. So with that,
so let's bring this to healthcare, and Verica, you want to pick it up from here?
Sure. So kind of digging deeper into the actual bulletin, the OCR bulletin itself, the first conversation you really have to have is looking at the type of information that these tracking technologies collect and really figuring out, does this fall into the category of PHI? So I like to view PHI kind of as a broader umbrella term definition, so to speak. And in the context of this bulletin, we hone in on individually identifiable health information, which is a little bit more intricate and is basically tied intricately to that person. So that's stuff like particular diagnoses, any type of payment information, login information, for example, if you're looking at like a member portal, your email address, it could be something like even your IP address or your geolocation. But individually identifiable health information, I cannot say that acronym, by the way, really it can go to your, in your mental or physical health condition. It's got to tie directly back to the individual and be easily, noted as tying back to that particular person. The privacy rule kind of gives two different carve outs for de-identifying PHI. I'll start with the easiest one first, which is expert determination method. And that's usually an expert that's identified and does a written report that statistically shows that any chance of re-identifying a person once the data has been de-identified is small. It's going to be a written report that will have to be, the covered entity would have to keep and be able to provide to a regulator to justify why it would be in compliance with the privacy rule. The one that I think deserves a little bit more conversation would be the safe harbor rule, which is you're removing every piece of identifiable data to de-identify. So that's name, that's geographic subdivision, so that's stuff smaller than the state. That's any elements or dates like a birth date, treatment date, date that a prescription was filled that can be tied back to an individual. IP addresses, I think that's one that is often kind of overlooked, but it does in fact fall into this category. Social security numbers. The safe harbor method of de-identification would be the one that kind of would be the most commonly used. Next slide. So when we really look deeper into the bulletin and look at the information that is collected on an entity's website, I think we kind of have to look beyond what we commonly think of as PHI and look at basic thing. It doesn't necessarily have to be that you have a relationship with that regulated entity. Example, if you're on a hospital's landing page, let's say you've never gone to that hospital, you're not currently registered, it's not a login page, but let's say you're on there looking to see if, for example, an appointment might be available at that particular hospital system's urgent care. That could arguably be considered PHI. It doesn't necessarily have to contain specific treatment or billing information, but anything that can tie you back. That's why the focus on landing, like login pages, member portals, that kind of thing, bears a lot of importance when you're really looking at what comprises online PHI for purposes of tracking technology. I might also highlight the third bullet, which is the identifiers have to be tied past. It can be tied to your past, present, or future health. So that's diagnosis, prescriptions, treatment, anything, and also any type of payment information. So for example, for my purposes, because I work for a large health insurer, that could include any member identification, group numbers, that sort of thing, that could also be considered PHI. So To an extent, for purposes of tracking technology, OCR somewhat broadened the definition, in my opinion, but also narrowed it a bit for this context by really carving out what is individually identifiable health information. With that, I will pass it to Amy.
Yeah, it's me.
Yeah.
Thanks, Erica.
All right.
So far, pretty theoretical, right? So we have all of these, this broad definition of IIHI, and Erica, I don't pronounce the acronym either. I just just say the letters, it's a lot easier. So, we're all begging, right? OCR, please help us, because everyone has a website. They're all publicly available. It can't all be PHI. And the bulletin helps us somewhat make that determination. So OCR distinguishes between data collected on user authenticated web pages versus unauthenticated web pages. And here's how they define them. So a user authenticated web page is an area of the website that requires you to log in before you can access the web page. So this includes areas of your website like patient portals, or telehealth platforms, or member portals if you're an health insurance company. On the flip side, we've got unauthenticated web pages, which are web pages that are publicly available. Anyone can access them. You can access them for research. You can access them for, whatever you want. And they don't require you to log in. And OCR's opinion of the data collected on those user authenticated web pages is a bit clearer. They say because user authenticated web pages contain PHI, so you're in a patient portal, you're booking appointments, you're getting test results, that is clearly PHI. Tracking technologies placed on those pages would in general have access to PHI. And so they say when you install tracking technologies in your user authenticated web pages, you must, one, ensure that the disclosures of PHI on those pages or collected on those pages is permissible, meaning that it's permitted by the HIPAA privacy rule, or you've gotten authorization from the patient to disclose that data to your tracking technology provider. And that you've entered into a business associate agreement with that provider if they have access to the PHI. So here's a common example. Let's just say you've got a tracker in your patient portal. Maybe you've got an analytics tracker there. Depending on how you've configured that tracker, and that's a really important part of the analysis, the vendor might be receiving identifiable information, that IIHI, about the patient's device, let's say their IP address. And they may also get form fields, depending, again, how you've configured that tracker. So they might get, reason that you've requested an appointment, or the doctor that person is requesting an appointment with. And per the bulletin, OCR would deem that information as PHI, and you as a covered entity or a business associate would need to put in place a business associate agreement with that provider or with that technology vendor. Sab, if you can go to the next slide. Unauthenticated web pages are a little bit trickier. And OCR's guidance is a lot less clear. They say tracking technologies on unauthenticated web pages. So again, this is your hospital marketing website page, the one that is publicly available. They say that in general, tracking technologies do not collect or have access to PHI, and therefore are not regulated by the HIPAA rules. However, and this is a really big however, even on those unauthenticated web pages, like Erica was saying, you still must look to see whether the information collected by the tracker is IIHI, whether it relates, it's identifiable to an individual, or whether it relates to someone's past, present, and key future healthcare. So you might be have a potential patient looking to book an appointment that's never come to your hospital or your doctor's office before. If it relates to their future treatment, it might be PHI. And so the bulletin offers actually two examples of when data collected on an unauthenticated web page is PHI. So the first is the login page to your patient portal or your member portal. So this is when somebody's navigating on your website, goes and clicks the login button at the top right-hand corner of the screen and gets to that page where they enter in their username and password. And OCR says that although the person hasn't been authenticated yet, although they have not logged in, the trackers there nevertheless do collect PHI, just such as login information or registration information. And so as a result, you might need to look at that a little bit closer and see whether the vendor of the technology on that page is actually collecting the data that the potential patient or the patient is submitting. The second example that they use is unauthenticated web pages that address specific symptoms or health conditions. So this is, for example, you have a page about diabetes on your website and the providers of the diabetes, and you have maybe educational materials about common ways that someone can treat their diabetes. OCR says that trackers on these web pages may also collect PHI. So unfortunately, OCR doesn't really elaborate on this example, which is, all of us were sort of scratching our heads being like, this is really, I think, the most problematic and difficult analysis to do, right? Because everyone has these web pages that describe sensitive health conditions. And just by nature of somebody visiting, this could be PHI. But one thing to sort of think about when you're doing that analysis of whether those pages and the trackers on those pages do collect PHI is whether, there's any reason to think or any colorful argument that you can make that that person is not actually a patient and they're not actually doing any viewing of that web page for their personal, treatment, payment, or healthcare purposes. And so it's a tough one. And it's sometimes where, you need to make a risk-based decision on whether it makes sense to have trackers on that page, whether it makes sense to put a business associate agreement there. But again, that's one of the head scratchers, very, very, very gray areas of this bulletin.
Amy, I also wanted to add in just a thought about mobile apps.
Yeah,
to the
please.
extent that you have them. And one really interesting example that comes up is, for example, when you're dealing like with a hospital system or a particular provider that, let's say, may have a mobile app. And I think of, as an example, our local children's hospital here in Atlanta, Children's Healthcare of Atlanta, that has an app. And when you go into the app, let's just say maybe to check your child's symptoms, which many of us have done. Or they have a link for urgent care where you can book there. The mobile app collects your network and your geolocation. It also collects your device ID. And so that, for purposes of this, could fall under that, umbrella. And so, for providers and hospital systems, to the extent that you have a mobile app and you're understanding that people are accessing it and you have geolocation data, you really need to think long and hard in terms of what type of tracking technology, if any, would be applied there. So I just wanted to point out, be mindful of the apps as well.
Erica, that's brilliant. That's a great point. And if we can go to the next slide, Erica, it's like you knew it was coming. I mean, Erica's exactly right. So the bulletin, we've been talking a lot about websites, but the bulletin, of course, addresses mobile apps. And as Erica said, those are also places where PHI can be collected. And similar to how the bulletin addresses unauthenticated versus authenticated web pages, they make OCR distinguishes between mobile apps offered by regulated HIPAA entities. So like Erica said, a children's hospital, which is a HIPAA regulated entity. If they're offering a mobile app, more often than not, that mobile app is going to contain PHI, and any tracking technologies used in that mobile app will collect PHI, and you need to follow the HIPAA rules with respect to those relationships. Mobile apps, on the other hand, that are offered by non-regulated entities may not collect PHI, but asterisks, You need to look at the relationship. You need to look at how it's being offered, who it's being offered to, whether, there's a way to sign in or not. And so again, it turns to a fact-specific determination, but like Erica said, it is, you can't ignore the mobile apps just because they're not on, using cookies and traditional tracking technologies like websites do. They still do collect data, and that data still may be PHI. So I think, oh, Erica, go ahead.
Oh, what I was gonna say is, in terms of, and I think we've mentioned, it's been mentioned earlier, you really have to be mindful in terms of the privacy rule and tracking technology, not just, depending on having that privacy policy or a statement in place. You really need to be mindful and really just thoughtful about whether you need to have a BAA in place. Like, is this the scenario for it? And is the disclosure going to be under the privacy rule? Is it going to be for a permissible purpose? You kind of have to look at the relationship and the purpose for the disclosures. The healthcare operations, particularly when you're looking at these apps, or for what, but also really just thinking long and hard about the necessity of having a business associate agreement in place.
Segue, yet again, it's almost like we plan for you to help with our segues between slides. So yeah, I think that is a great job. Why don't we go to the next slide here? So if you are going to use these technologies and you're potentially in the realm where HIPAA applies to the data, what do you need to do, right? We've been talking about, like, what is technology? It's been, when does it apply? But okay, everyone usually wants to just know, just tell me what to do, right? So if you're going to use these technologies, remember the HIPAA baseline of don't use or disclose PHI without an individual's authorization unless 500 pages of exceptions, right? So one that you need to keep in mind, though, is most organizations are not going to be able to get a true HIPAA authorization, right? In writing, signed, et cetera, in order to disclose PHI, particularly for these kinds of use cases involving online trackers. So you need to find a pathway that might permit the disclosure without an authorization. So, the main ones, obviously, TPO, treatment, payment, healthcare operations. And what OCR says is most website analytics would probably be healthcare operations, right? So you don't need an authorization to engage in those sort of healthcare operations. But many of these technologies could be used for other things that might require an authorization, like marketing, right? So yeah, everyone knows general rule. If you're going to use or disclose PHI for marketing, you need an individual's authorization. Obviously, there's some exceptions, right? So if you're a covered entity, trying to do marketing about your own products or services, that's different than if you were trying to market others. But the Bulletin does say you would need authorization if you're doing marketing, and there's not some other exception that applies, right? The other one that is, hard to implement, but still, required, and something that we know that OCR is looking at, is whether you're complying with the minimum necessary. And it's a bit inconsistent with how this sector works, right? The whole way that online tracking technologies, and particularly for advertising work, is they just try to suck up as much data as possible to create these profiles about people and insights, and try to figure out more things about the individual, based on their device, based on their interests, based on what websites they view. And, the code that is used often isn't limited to just send the IP address or just send what page the person's on, right? It's sending a whole dump of often information about the device. And, the key thing to keep in mind is, are you really complying with the minimum necessary here if you're otherwise permitted to do this under HIPAA at all, right? The other one is, if you're using a vendor to help with these things, even if it's healthcare operations, something like that, you need a business associate agreement. The main issue here is most companies in this space, not all, but most, they just don't sign business associate agreements as a routine part of business, right? So that means you're either going to have to find one that does, or, try to shut off some of these technologies, at least on pages where it's clearly PHI or higher risk. And, what we do with a lot of clients is to help figure out where that line is, because it's not going to be a bright line, yes, no, right? We know some things are clearly yes, PHI, and some things are probably no, not PHI, but the gray area is really a large part of it. And that's where I think, really having someone that understands the technology, understanding what's market, where you fit into market, and risk tolerance is really important, because chances are you probably aren't going to get most of these third parties to sign a BAA, right? And as mentioned before, the HIPAA compliant authorizations. Do folks have questions about this as we're going? I think I saw something may have popped up. Why don't we come back to that a little bit in just a few minutes, because I don't think it's like a quick yes, no. So when we go to the next page here. All right, security rule. So if your tracking technology is going to be basically processing ePHI, you also have to comply with the security rule, right? And the key things to highlight here are OCR says that they expect that covered entities and business associates will include the use of these tracking technologies in their enterprise-wide security risk analysis. That's that administrative safeguard in 308 that requires a comprehensive look at all the data flows, the threats, the vulnerabilities, the resulting risks, how those risks are mitigated by controls, and the resulting risk, and then how do you reduce blah, blah, blah in that one enterprise-wide document. And, most organizations I know, at least until recently, weren't generally including that in their security risk analysis. So it's an important call out that if you are going to do this sort of thing, particularly on like a login page, to include it in your security risk analysis. Other things that OCR calls out is you need to encrypt ePHI in transit. Well, there's another issue. Most of these technologies are not built to encrypt in transit. So again, consider that, and maybe the solution is you just turn them off on some of these pages, or maybe you just have to take some risk. But those are the things that OCR is requiring and telling us in that bulletin. Why don't we keep going to the next page? All right. So what happens if you mess up? Or what happens if you?
I'll cover, Elliot, I'll cover this one.
Yeah, exactly.
So let's say after this webinar, you go back, you look at your trackers, and you figure out, I'm in a position where I might have tracking technologies inside my patient portal, and I haven't taken the necessary steps to comply with HIPAA, or I have no idea, but I doubt we've signed a business associate agreement. So the first step is don't panic. Things will be fine. The second step is, at least from a regulatory perspective, is to determine whether the tracking technology, one, in fact collects PHI, and two, whether the disclosure of PHI to the vendor is a breach that would trigger reporting under HIPAA. So just like any other potential breach under HIPAA, like accidentally emailing patient records to the wrong email address, which happens frequently, we look to the HIPAA breach notification rule for guidance on how to evaluate. And so as a general rule, unless an exception applies, a user disclosure of unsecured PHI, and again, like Elliot said, some of these are not configured to transmit data securely, so that we might have an issue of unsecured PHI here. So any user disclosure of unsecured PHI is presumed to be a breach unless you can demonstrate what the HIPAA rule says as a low probability of compromise based on a risk assessment of 4 factors. And we've listed those 4 factors on the slides. I'm going to take the first 2, and Erica, if you want to jump in on the third, that'd be great. So the first factor is the nature and extent of the PHI involved. And this includes the types of identifiers that might have been disclosed and the likelihood of re-identification. So this factor examines what type of data was shared and the sensitivity of that data. So you want to consider the level of detail of any clinical information, any sensitive categories of PHI that might have gone over. So I think I said earlier, like if a field in a form went over and someone disclosed they've got a mental health condition and that's the reason for their appointment, that is going to be a sensitive category and will weigh that factor as a higher risk. You also, again, want to consider whether the individuals can be re-identified. So you can ask whether that data that was disclosed to that vendor includes direct identifiers or indirect identifiers. you have to also think about whether the vendor has the capacity to re-identify the person based on the potential wealth of information that they have access to. So that's the first factor, and you sort of determine whether there's a high risk or a low risk for that factor. The second factor is whether the unauthorized person who whether the unauthorized person either used the PHI or misused the PHI that they received. And the unauthorized person here, of course, is the tracking vendor. So when you think about evaluating this factor, we often look at the vendor's reputation, what policies they might have in place to limit their own use and disclosure of the data, how they generally treat the data, and whether they're at the end of the day obligated to protect the security and privacy of the data. So they may not have a business associate agreement in place, but maybe they have other data processing terms that say, we will only use the data for X, Y, and Z purposes, and that is generally in line with the services that they provide to you. So with that, the third factor, Erica, if you want to cover that one.
Sure. This one is what I call the rubber meets the road. Whether or not the PHI that's at issue was actually acquired or viewed. The example that I think of is in the context of one portion of our business, which is the health plan business. Let's say a member logged in to look at a particular claim, or maybe was just on another landing page looking at something related to a diagnosis or condition. What was the PHI that was provided? Did someone actually acquire it or really see it? If they looked at something related to their diagnosis or condition, was there actually, I call this, was there really a harm that occurred? And the fourth one would be the extent to which the risk to the PHI was mitigated. What was done to block it, if you know what I mean. Those would be the factors.
Yeah, thanks, Erica. So at the end of the day, you know, if you end up in this position where you might have disclosed PHI to a vendor, you have to go through this exercise, but you also have to think about remediating your current situation. And so everything needs to sort of be done deliberately and carefully to make sure you're sort of mitigating your risk along the way. So with that, I think we can go to the next slide. We're going to step out of HIPAA land and go into a world where the PHI or the trackers are not collecting PHI, but they're just collecting PII, personally identifiable information.
Thanks, Amy. Yeah, so like Amy said, outside of HIPAA, there's a number of requirements under state laws to provide opt-out rights for the kind of activities that implicate tracking technologies and advertising. So kind of a threshold question that we frequently answer with our clients are, what are your obligations as a company in the health space to actually comply with these state law obligations? So if you are a covered entity or a business associate, you might be subject, only some of the data that you handle might actually be subject to these state laws in California. And then you might all be entirely exempt from the state laws in Virginia, Utah, Connecticut, Colorado, because they provide pretty broad exemptions for any entity that is subject to HIPAA versus California that only provides an exemption for data that's subject to HIPAA or PHI. So any information that you handle that is not considered PHI will be subject to those state laws. So what we do with a lot of our clients is kind of follow the process of data as it's collected and try to figure out the point at which it becomes PHI. And then anything before that, when it's just PII, will be subject to these California requirements. So taking it back to 2018, California kind of started this out by providing an opt-out of sale. And a sale was pretty broadly defined, which made that super fun for everyone, which is making data available for monetary or non-monetary consideration. Non-monetary consideration sounds like it could be anything, and it can be services that you're contracting with for another party. And the AG actually weighed in on this as well, so saying that a sale happens also when a third party directly collects data from your website. So there was kind of this conception for a long time that yes, using tracking technologies, allowing a third party to directly collect data from your website for advertising purposes is a sale. because that service, that advertising service that's being provided is the non-monetary consideration, and making that data available still counts as a sale, even if you're not affirmatively transferring it to the third party. And this applies a lot in analytics context as well. So it's not just advertising. If you're allowing a third party to directly collect data and provide you with analytics services, that again could be considered non-monetary consideration. And then fortunately or unfortunately, depending on how you look at it, in 2020, California amended the CCPA with the California Privacy Rights Act and added this new category of sharing. So sharing actually very specifically focuses on advertising and focuses on what is called cross-context behavioral advertising. So basically the types of advertising we touched on earlier, collecting information across different web domains to create kind of a profile and tailor advertising across other unaffiliated websites. And a lot of these other states, Virginia, Colorado, Connecticut, Utah followed suit. And they also added an opt-out right for targeted advertising, which is functionally similar to what I described as sharing. So now not only are there sale obligations, there are also sharing and targeted advertising obligations, which specifically focus in on advertising. So even if you might try to make the argument that something might not be a sale, this addition of the opt-out for sharing and targeted advertising was designed to specifically focus on the use of cookies and tracking technologies across different websites for advertising purposes. So
This is Erica. Oh, I'm sorry. Go ahead, Saba.
Oh, no, yeah, of course. I was actually going to say, I know Erica has a fun story about this one, if you want to go ahead and share that.
I will say it's a fun story, but it's kind of more of a pattern that I'm starting to notice when we are negotiating some of our privacy agreements, particularly in the vendor space. This has become a heavily negotiated and debated. I have not seen language added in up until recent months that really address sharing and particularly the monetization and the financial piece, remuneration, if you will. Up until recently, I am currently in the midst of negotiation with a fairly large employer group. And this is truly a stumbling point for us in terms of finding middle ground with them, particularly when it comes to the financial consideration for the tracking and the hits. So I just wanted to mention that this is something to really be thinking through in terms of language alternatives when you look at your privacy documents, particularly with California-based vendors, and this is a California-based employer group, I might add, it's becoming a bone of contention. So be prepared, walk in forearmed, and don't necessarily write that area of language off as one that'll be easy to agree to like it used to be. It's not anymore.
Yeah, thanks, Erica.
Mm-hmm.
Yeah, I think that's really important when you're thinking about implementing this opt-out right. Because you need to be, when you're offering the right, typically you're offering the right together, right? So you're allowing people to opt out of both sale, sharing, targeted advertising. So not only do you need to look at your advertising activities and your cookies and your tracking technologies that might be kind of immediately evident in this advertising sphere, but you also need to look at some of the things that Erica talked about. So under your contracts and agreements with different parties, which of those kind of activities and data sharing arrangements might be considered a sale, such that maybe just implementing like a cookie banner or consent management platform might not fully cover all of the sale or sharing activities that you're actually conducting. So what we do a lot with our clients is try to figure out what the best way to implement this opt-out is. Sometimes it could be a web form, which allows you to collect maybe like email address and things like that to opt out of maybe more specific types of sales or sharings that are going on under contracts with different types of parties. And then once that web form is submitted, kind of a first party cookie drops and prevents data from being shared with third parties and additional data from being collected. Or if your advertising activities are a little more straightforward and are just kind of focused on your website and cookies and tracking technology, for advertising purposes, maybe a consent management platform or a preference center that not only disable cookies, but also all these types of tracking technologies. That might be the better way to go. So a lot of kind of implementing this opt-out mechanism is trying to figure out the full universe of not only advertising that falls under sale and sharing and targeted advertising, but also sales. And then the last thing I want to touch on before I pass it off to Elliot to elaborate on these requirements a bit more are just flagging that some of the newer laws, Colorado and Virginia in particular, have requirements to conduct risk assessments for any sales or targeted advertising activities. And Colorado, about a month ago, released regulations that provide really granular requirements for what the content of those risk assessments need to look like. And California has a general risk assessment requirement for higher risk processing, and the California Privacy Protection Agency is currently in the rulemaking process to figure out what constitutes higher risk processing. So with that, I'll pass it off to you, Elliot.
Would help to unmute. Just for the sake of time, just very quickly, global privacy control is a new requirement. It's, both in California and will be in Colorado. And what it's sort of like do not track version 2.0, right? Everyone in the industry got together like 15 years ago and tried to come up with a way to have browsers basically signal, don't track me across sites. And they ended up, basically compromising on, well, websites need to tell you whether they do or not. And that's what we have under California's CalOPA. What these new rules are saying is that if you have a user-enabled signal that says, don't sell my data or share my data for targeted advertising, that needs to be automatically detected and honored technologically. And in California, we don't really have a lot of detail on exactly what technologies count in which don't in terms of identifying them by name, but Colorado will, starting in July 2024, or publish the list before then, but become effective after that. Give us a list of which technologies. But just for the sake of time, why don't we go to the last slide and just some closing thoughts. And again, if you had a question, we can get to it, feel free to reach out.
Yeah, so you might be thinking, where do I start? So for this purposes, we always recommend building your foundation, which will involve figuring out what tracking technologies you use, both on your websites and mobile apps, the names of the vendors, and then the contractual terms in place. And those are not always easy to find. There are self-help tools out there. There are publicly available plugins for browsers that can help you at least take an initial look at what's on your website. And there are also, McDermott, our team does it. There are consultants out there that help come up with that list of trackers. And it's not necessarily going to be consistent across each of your web pages. So it's important to do an examination of some of your main web pages or the ones that might be particularly sensitive, and to get a scope again of what you've got on your websites and apps.
Okay, the next step is really to identify any individual tongue twister identifiers and health information that is collected. And the example I give is, I know that my organization did a very holistic approach and looked at our landing pages. We looked with a lot of specificity with the member portals and our login pages. But then we also looked at some of the other like product offering pages, the clinical pages that really, help members with disease management, to look at the type of tracking that was on most of those. And I know that with the risk assessment, the tracking technology was removed, or just was never there for those landing pages, which would go into what we call the authenticated user bucket. So I just think those risk assessments, also known as the ROCAs, are super important to really identify. Obviously, determining whether any PHI uses or disclosures comply with HIPAA, to include the carve out that we discussed earlier, which is the individual identifiable healthcare information, and understand and always recall that it comprises some stuff that we don't always assume, which is geolocation, other things that wouldn't necessarily be a part of like login credentials, et cetera. So.
Just a final thought, I know we're at time, this isn't a one and done sort of thing. So you might want to look at implementing a consent management platform or a CMP tool. OneTrust is just an example. There's lots of vendors out there that do this and implementing global privacy control, but make sure that it's not, you look once and that's it. You should have a process for if you're going to add a new technology that's going through a review, seeing whether it has PHI involved, because, my experience where most clients and their marketing departments are like every week or every month, there's a new technology they want to put on for a campaign or something like that. So make sure you have more of an administrative, holistic process for addressing these issues. And of course, if you have questions, reach out. And with that, I know we're at time. So I want to thank Erica, Saba, and Amy so much for joining and doing such a great presentation, and thank all of you for attending. Hope it was helpful. Thanks, everybody.